Do you need an ERISA disability attorney? Well, of course, you're going to expect me to say yes because I am an ERISA disability attorney. But the answer is really, yes, you do need an ERISA disability attorney. Why? Because an ERISA disability attorney understands policy language, the definition of disability, own occupation, any occupation. They understand the limits in a disability policy, and they can apply that understanding to your specific case. Many times claims are denied based on the lack of objective evidence of the diagnosis, the disability, or a causal relationship. And it's crucial that you anticipate those potential denial bases before you even stop work and apply for benefits. So many times I'm looking at that policy. I'm looking at my client's medical records. I'm looking at their earnings. I'm trying to decide whether or not they're going to meet the standard of definition of disability in their policy. I'm looking at how the medical evidence may or may not establish restrictions and limitations. I'm looking for evidence that those restrictions and limitations are not only objectively based, but interfere with your ability to do the material and substantial duties of your own occupation. And additionally, I am looking for policy limitations. So there might be subjective medical condition limitations or psychiatric limitations in your policy. And so I'm developing a strategy to maximize your benefits from the very beginning. So it's really important, I think, before you stop work and apply for benefits, that you retain a disability attorney to do a consult, to review your policy, review your medical records, and give you some guidance. And if you're smart, you will retain a disability attorney to help you through the claims process. If your claim is denied or terminated, you only have 180 days in which to file an appeal. And the appeal is the trial of your case. You can't hold your evidence till you get in front of a court because the court will not look at that evidence. You can't run to court without filing an appeal. And the appeal process is one in which you've got 180 days in which to file that appeal. You've got to get the carrier file. You've got to understand the reasons for the denial. And I will normally see 12, 15, 16 reasons that I think the decision is wrong. And I'm writing legal arguments. I'm developing the medical evidence, the vocational evidence, the lay evidence that will establish the basis not only for the claim, but to overturn a wrongful claims denial. Look, my dad became disabled when I was growing up, and I watched him struggle to make the difficult decision to stop work and apply for his benefits. If his claim had been denied, he was in no shape to file an appeal. He was an insurance agent. He knew disability insurance policies, but he was dealing with his medical condition. He was dealing with how to handle the family finances, how to deal with all the associated issues that come with disability. You don't have the effort. You don't have the base of knowledge in which to file an appeal. And quite frankly, you probably don't have the physical or emotional stamina to apply for benefits or file an appeal. So those are some of the reasons why I think that you need to have an experienced ERISA disability attorney at all stages of your claim.